The coronavirus epidemic has led to so many legal questions. A local attorney has been answering some of those with us over the last couple of weeks. He's joining me now to address some of the questions viewers posted on Facebook when we asked you what you wanted answered. Attorney David McDivitt is joining us now. David, thanks so much. Let's start with this. It is really important to parents, David. An anonymous viewer asked this. If you are working from home and no longer need daycare, but will need it when everything goes back to normal, should you pay the same price or a high price to hold the spot even when the kid is not even there? David.
That's a great question, and there are a couple of ways to look at it. If what you're concerned about is making sure that that person is still available, and you understand that they're not going to be coming into your house between now and that point in the future where they resume providing care for your children, there's nothing that keeps you from continuing to pay them money, even a higher rate, if that's what you have worked out with that particular provider. Now, if you are paying them, look, there are two ways that folks tend to pay babysitters or nanny and child care providers: on the books, and then some people choose not to do it so formally, which is a separate issue. But assuming that you're doing it formally, you're keeping track of their hours and reporting their wages, then you just need to make sure that you don't have them on call, which is a separate issue. If you're asking them to remain on call, you're going to have to pay them for every hour during which you expect them to be on call. But I think that's different from what this viewer is asking. What the viewer is asking is, babysitter, nanny won't come in for the next month, 2 months. I'd like to go ahead and pay them during this time, or even pay them more to make sure that they're going to continue to come and work for me. And that is really up to the discretion of the parent. Another thing that is an option too for parents with care providers is furloughing your nannies. For some of them, they actually may be able to go on unemployment, assuming you have been doing everything correctly and paying the wages the way you might do it if you were running a full business. Then those employees, if they're not able to come in and you're not able to pay them during this time, and there's no need because you are at home, they might be able to be furloughed. They can file for unemployment, let the unemployment office know that they have a job waiting for them on the back end. And then when this resolves and you're able to bring them back into the home, they can return, go off of unemployment, and you can resume the traditional employment relationship that you had with them before.
But David, what if it's a licensed facility that, a lot of parents have to hold spots for 6 months, a year ahead of time?
Yeah, and that brings up a whole different question too. There are some provisions that are allowing certain child care providers or agencies to continue to provide certain child care. But if what you're asking is, how do I reserve my spot? That is going to be down to the entity themselves. What are they doing to protect the expectations of the parents who know or have anticipated that they'll be bringing their children back into that child care at the end of this time in which those children are at home.
So it sounds like they're going to have to look at their contract too that they have with their child care facility.
Right, and if they're contractually obligated to continue to pay, but then the provider for some reason is not able to then keep their doors open, yeah, that is a matter of trying to work that out and understanding, look, we're not getting what we were contracted to pay for either. We're sensibly paying for. And so, you look at that on a case-by-case situation too.
Okay. I want to get to viewer Nikki Ray's question. She said, can parents hold kids from the other parents because of this? Of course, a custody question. Can you answer it in a minute, David?
Nikki and Diana sure can. Here's the deal. No. The governor was even explicit in his stay-at-home order to permit traveling. But for example, if you're going from Castle Rock to Pueblo West, and somebody else asked that question as well. You're allowed to do that to transport your child to affect that transition. Now, there may be some situation that is unique to a particular family, a medical issue. One parent has a medical issue, and it's really important that the children aren't going to another home where they might be exposed to something, and then bring that back into the home where that person has a medical sensitivity. So I'm encouraging couples or parents to try to work together and come to some kind of amicable resolution if they can. The courts are still open to hear motions, emergency motions to restrict parenting time if there's a specific health reason that perhaps the other parent, the person who you might not want your child to go and stay with, might have that would make your child more vulnerable or make you more vulnerable. For example, if they have the coronavirus, if the other parent does, you stand a much better chance of then being able to keep your child from going to visit their other parents.
Okay, David, we're going to take a quick commercial break. When we come back, he's going to talk about some evictions and what legal responsibilities employers have. We'll be right back. Welcome back. We asked for your legal questions on Facebook. We're getting you some answers today with local attorney David McDivitt. He is back with us now. David, I want to get to viewer Colleen West. She is asking, are landlords and or mortgage companies allowed to start any type of eviction process at this time?
Well, it's a two-part question. The answer is possibly. There is right now nothing in Colorado that is actually prohibiting landlords from beginning the eviction process, save for two very critical roadblocks. One of them is that in order to really evict somebody, you need access to the courts. And the courts are essentially closed for most business right now. The other thing is that the governor has, in fact, ordered that law enforcement that operates on the state level not participate in any eviction proceedings. He has also strongly suggested that landlords not begin an eviction process, at least give tenants until the end of April, give us that time to kind of see where things are before they begin that. Now, he is, to the best of my knowledge, he has not issued any order to that effect. However, he is strongly advising municipalities to direct their forces as well not to evict. When it comes to mortgages, it's a little trickier as well. And the federal government has instructed, for example, the government managed mortgage entities, Fannie Mae and Freddie Mac, are basically putting any kind of eviction thing on hiatus or foreclosures, foreclosures on hiatus during this period of time for any of the mortgages that they back. Also, Housing and Urban Development has been instructed not to pursue any foreclosure actions on any FHA loans. So there are some specific restrictions at the federal level that are prohibiting foreclosures. And again, on the local level, if you don't have access to the courts, the landlord can threaten, but there's not much they can do about it right now.
Okay, David, good. We've got about a minute and a half left.
All
Shauna
right.
Steiner-Poor, she's got quite a question here, a long one.
Okay.
She wants to know, what kind of legal responsibility does an employer have to notify its employees that one of its staff has been presumed positive? Also, do the coworkers have a legal obligation to self-quarantine to protect fellow workers? And when does an employer become legally obligated to inform the public?
Okay. Generally, employers are not legally obligated to inform the public. However, when it comes to the people that work for them, if somebody does test positive, it is the employer's responsibility to speak, first of all, prohibit that employee from coming in. And so in that sense, they have a quarantine somewhat forced on them with respect to their workplace. The employer needs to find out, it's best practice for the employer to find out who that employee had close contact with over the prior 2 weeks prior to their diagnosis or showing symptoms. And then what the employer needs to do is go and tell those individuals, you were in close contact with somebody we reasonably believe to have coronavirus. They're not allowed to say the person's name to the coworkers. So what they will do is, to those people who had close contact, say, we believe you had close contact with somebody who we believe has coronavirus, and therefore you might be exposed. They are under no obligation, though, to make some kind of proclamation to their entire organization, specifically saying so-and-so, in fact, to prohibit it from saying so-and-so has it. They have to comply with OSHA standards, the general safety standards. OSHA is using the CDC guidelines. They've baked that in. So employers must follow what the CDC guidelines are right now for keeping a workplace safe. If they fail to do that, they're in violation of OSHA, and that's where they can be in trouble.
Okay,
and
well,
that also,
go ahead.
Go ahead.
No, go
Well,
ahead.
it also informs, what kind of, for example, protective equipment that they are supposed to provide their employees. There is a list of what they're supposed to do in order to keep the workplace clean and ostensibly virus-free. If they find out that somebody had coronavirus in their building, there are certain precautions they have to take to clean it. They have to even shut down for 24 hours prior to cleaning. But there are restrictions that employers have, but they don't have to tell the general public. and the person who was quarantined must obey by the stay-at-home orders. If there is a government quarantine for that particular person, then they would have to be forced to actually be quarantined. But at least the employer can keep them out of the workplace.
Okay, I think you got all of her questions answered right there.
Right.
David McDivitt, we are so grateful for your time. We thank you so much. We're back after this.